Welcome to the Virtual Center for the Study of the United States Constitution with your host, Dr. Bill O'Brien.
Good afternoon. This is Bill O'Brien. We're beginning a new week. We are into the month of June in the year 2013. It's hard to believe that we're almost halfway through the year 2013. Time flies when you're having fun, does it not? I find as I get older that it flies faster and faster and faster. Or maybe I'm just moving slower and slower and slower. I don't know. But anyway, it sure is a pleasure to be with you today. Let me begin, as we always do, by encouraging you to participate actively in our program by giving us a call and joining in the discussion and making sure that what shows signs of being a monologue can be indeed a dialogue, and that basically means that you have decided to give us a call and share with us, not just with me, but with all of our listeners, your ideas and your insights about the issues at hand, whether they be issues that we covered in a previous program or ones that you think we ought to cover in a future program. And if you'd like us to revisit certain issues, by all means, feel free to do that. The phone number we do invite you to call is area code 304-658-3333. That's 304-658-3333. And again, if you'd like to email me directly, on a program, an idea, a comment, a criticism, a suggestion, an observation, whatever it might be, I would love to hear from you. I appreciate the time that you would put into such an email, and I promise that I will do the very best I can to respond to you in kind. And by in kind, I mean to put at least a portion of the time into the issue as you put into the initial email. My email address is waobrien906@gmail.com. That's waobrien906, all one word, no punctuation, @gmail.com. You will recall that when we were last together, we were talking, I believe, about Supreme Court cases, and we were moving into issues related to the Supreme Court. I had in mind a couple of specific cases that I wanted to revisit, not revisit, but visit for the first time, because we haven't done either one of these before. And the specific areas that I wanted to get into were the areas of the Commerce Clause in the Constitution, primarily looking at the John Marshall decision in the case of Gibbons versus Ogden in 1824. The second case that I really wanted to focus on is a case that doesn't appear in many of the textbooks. It appears in constitutional history books and in law books, but not in American history textbooks. It's a case that few people who are listening would probably have had occasion to encounter. It's a decision that the court rendered in 1837, and the title of the decision is Charles River Bridge versus Warren Bridge Company. It's a Massachusetts case. And it was decided, finally, in 1837, 2 years after Justice John Marshall passed away, and the court was under the tutelage of its new Chief Justice, who was Roger B. Taney. That's Taney, Taney. And Justice Taney, some of you may recall, was the as I recall, was the director of the United States Bank in Maryland during the decision of McCulloch versus Maryland in 1819. And he was appointed to the Supreme Court, became Chief Justice after John Marshall passed away. And the Taney Court is a very, very significant, interesting court. It's obviously not as media worthy or as interest attracting, if you will, as was the Marshall Court. And I think it suffers. The Taney Court suffers primarily because Taney had the misfortune of following one of the greatest justices, not only that the court had ever had up until that time, but one of the greatest chief justices that the Supreme Court has ever had in its history, John Marshall. That's part of the reason that that Justice Taney and the court he headed have suffered. The second reason is that Justice Taney was Chief Justice during the infamous Dred Scott case in 1857. And the court suffered immensely as a result of that decision. It took the court years to recover from the negativism directed toward it as a result of the Dred Scott decision in 1857. Everything I've read seems to suggest that Justice Taney believed that in rendering the decision in Dred Scott, he was not only interpreting the Constitution, but he was basically holding the Union together. It was a decision that obviously favored the slaveholding states, the South, and Taney believed that, with the threat of Southern secession always in the air, a decision like the one reached in Dred Scott, which upheld the sanctity of property in slaves and basically legitimized and called attention to the federal fugitive slave law. It was a decision that he believed would keep the South in the Union. And, of course, it might have done that, except that the negativism in the North, especially, that decision produced, led to a tremendous strengthening of the Republican Party, and ultimately, 3 years later, led to the election of Lincoln as a Republican candidate. So, in a sense, the strength of the Republican Party and its ability to nominate Lincoln as its candidate, and the fact that Lincoln was able to win the election of 1857, there's absolutely no question, was all part and parcel of the outrage in the northern part of the United States over the Dred Scott decision. So in a sense, the Dred Scott decision backfired on Justice Taney. Rather than holding the nation together, it ultimately was probably a major factor in the disruption of the Union and ultimately the Civil War that followed. And it took, as I mentioned, it took the court years to recover from the negativism of the Supreme Court. Anyway, those are the directions I was going to go, and I wanted to spend some time on the Commerce Clause, and specifically looking at the case of Gibbons versus Ogden, and especially to focus on the significance of the Commerce Clause and the definition of commerce that John Marshall reaches in Gibbons versus Ogden. It's a very important case. It's one of the key cases that is usually cited in looking at the major cases, major decisions rendered by the Marshall Court. That was my plan, and in order to stay relevant, and I mean this, in order to stay with the flow, so to speak, or to get with the message, to stay with the intent of the very creation of something like a virtual center for the study of the U.S. Constitution, one of the things I don't want to allow to happen is to let major issues related to the Constitution pass without linking what we're doing to what's happening in the world around us. After all, I think it's kind of an unspoken objective of this entire program is not only to look more carefully and more substantively at the Constitution and at its ramifications in terms of the way it affects our day-to-day lives, but also to focus on those aspects of things that are happening in our day-to-day lives which directly affect the Constitution and affect all of us in the process. It seems to me, in a nutshell, it seems to me that there's going to be much more willingness and much more interest in the substance of the Constitution as people begin to appreciate more and more the impact of that document and its interpretation on the way we live our day-to-day lives. As you know, I'm broadcasting from southern West Virginia. And at the end of last week, since our last time program together, the courts have reached a decision in a case which is getting a lot of publicity, a lot of play here locally. And it's a case that was rendered by a circuit court in St. Louis, Missouri, toward the end of last week. And it's a very, very significant case involving Patriot Coal Company. And without going into all of the details, let me just share with you in brief form what that decision was about. Patriot Coal was a company created a few years ago from its mother company, which was Peabody Coal. It's a spin-off corporation that was created a few years ago. And Patriot Coal hasn't been in existence that long, but in the last several months, with coal experiencing as much competition, first of all, as much negativism as coal is experiencing from, for example, the EPA, the Environmental Protection Agency in Washington, and a number of other things, competition from natural gas and various other things. Fact of the matter is, coal is, in a number of ways, is on the defensive. And of course, West Virginia economy for years, for decades, has been based upon coal. And so in West Virginia, any kind of an attack on coal is considered to be an attack on the state, because the livelihood of the state for so long has been so dependent on the mining of coal and the price of coal and the need for coal. And the point is that a few years ago, Peabody Coal matriculated into a new company called Patriot Coal. And within the last year, Patriot Coal applied for bankruptcy protection under the federal bankruptcy laws. And the issue that became relevant was obviously, the issues that attracted everybody's attention, of course, were the obligations that Peabody Coal created or was responsible for related to miners and their families, especially retired miners. More specifically, pension plans and health care benefits that over the years were promised to thousands of employees and their families. And those responsibilities, those commitments, retirement commitments, were inherited by Patriot Coal. And as part of Patriot Coal's application for bankruptcy protection, the company made it very clear that there was no way in the world that it was going to be able to honor the pension commitments and health care commitments given to retired coal miners, not only here in West Virginia, but in other states as well, Kentucky, a neighboring state being one in particular. And as a result, for several weeks, there have been pretty healthy. In fact, the media has done a good job covering these demonstrations occurring in St. Louis as this decision was looming as to how the courts would deal with the responsibilities of Patriot Coal to its retirees. And at the end of this past week, I believe Thursday, I believe it was last Thursday, the court ruled in favor of Patriot Coal, basically arguing that the company was within its rights to suspend its obligations and commitments to its retirees as it began to restructure or tried to restructure under the bankruptcy legislation. This decision is obviously going to affect thousands of retired coal miners and their families here in the state of West Virginia. However, the significance of this extends way beyond coal mines, way beyond coal companies, because the potential here for damage to retirees in any number of fields, any number of occupations could be affected. In fact, the degree of surprise and the degree of horror with which many people in this area responded to the court's decision in this case is astounding. This past Saturday, for example, our local paper here in Beckley wrote an editorial and basically recounted the story of the case and presented both the company's rationale for being able to avoid or suspend these commitments to retirees, as well as the coal miners' position. And of course, the major arguments put forth by our local congressman, Nick Rahal, by Senator John D. Rockefeller of West Virginia, and many others. The position is that these coal companies gave their all for the company. Many of them gave their lives. Many of them are suffering in terms of health care as they reach old age because of the fact that they worked so long in the mines. And the position of the UMW, the United Mine Workers, and others, is that these people gave everything they had to the company. And when it came time for the company to basically come through for them, the company found a legal loophole in the bankruptcy laws which allowed it to forfeit its commitments and its obligations and its responsibilities, its humanitarian responsibilities to those who worked for it for so many years. In its editorial, our local paper concluded by suggesting that this decision is not only not fair and not only not right, but this is not the American way. That America stands for more than this. And beginning on Saturday, I sat down and started to put together a response, a letter to the editor type of response. I have not sent it in as yet. With today's program in the offering, I thought I would wait, and especially if some of you give me some input and respond to some of the things that I intend to say and argue in my response, I wanted to wait until I had an opportunity to hear from you, and until you had an opportunity to respond. So again, I've kind of opened created an opening here to once again repeat our phone number. It's 304-658-3333. That's area code 304-658-3333. Let me share with you, this is a rough outline, kind of a draft of the way I started, and I think you will begin to conclude very quickly where I'm standing. This is the way I opened. The recent decision in the Patriot Coal case, where Judge Kathy Surratt states, let me repeat that name, Kathy Surratt, S-U-R-R-A-T hyphen States, S-T-A-T-E-S, seemed to violate the rights of people over corporations by allowing the company's bankruptcy rights to trump pension and health care commitments to workers by its parent company, Peabody, has elicited outrage and surprise from most quarters. West Virginia Congressman Nick Rahall has joined with Senator Rockefeller to introduce legislation in Washington that would shield other miners from a like rollback. Our own Register Herald, the local paper here, termed the decision as not the American way. Legal maybe, but neither right nor fair. And this is the point of departure for me in terms of the editorial I wanted to write. And it goes right to some of the programs we've been doing in recent weeks. This May 31st editorial is only half right. It is neither right nor fair. But, I argue, it is in perfect harmony with the American way. From the Marshall Court in 1819 to Citizens United in 2010, the courts have gone out of their way to uphold the rights of corporate persons over real ones. John Marshall, in his two famous 1819 decisions, McCulloch versus Maryland and Dartmouth College versus Woodward, connected these two seemingly unrelated cases on the constitutionality of the United States Bank and the independence of Dartmouth from government control by affirming their rights as corporations. In other words, while one was a bank and another one was a college, they were both corporations. And as such, they were connected. And one of the things we've done in previous weeks here at the Virtual Center is to look in detail at Marshall's decision in each of those cases and focus on the fact that a good portion of each decision focused on the fact that the institution at hand was a corporation. And Marshall used that opportunity to go into the origins of corporations, his idea as to what they were and why they were necessary. And Marshall seemed to go out of his way to emphasize the fact that since corporations were incorporated, were created by government to carry out certain specified needed services as part of government's responsibility to promote the general interest, to promote the general welfare of the public interest, then it was very important, Marshall pointed out, to not overly regulate or over-restrain these corporations, leave them free enough that they could carry out their legal responsibilities under the original charter, under the original application for incorporation. So Marshall linked both of these cases around the fact that they were both corporations. Both of them were creatures of government efforts to promote the general welfare. both of them were should be independent of government control under incorporation rights as corporate persons. Both cases laid the groundwork for what would later become, decades later, Citizens United. The rights of corporations to enjoy the protection of our Bill of Rights as legal persons, yet remaining relatively free from the obligations and responsibilities of citizenship regularly assigned by the courts to real people. For example, corporations, by definition, reap the benefits of limited liability protections. Those who invest in corporations are only risking the money invested in the corporation itself. In other words, the law of incorporation shields corporate persons from being totally liable should something go wrong with the corporation. Citizens don't have that kind of protection. They have insurance, but citizens aren't entitled to that kind of legal protection. So what we end up with is a kind of contradiction in terms here. Corporations are actively pursuing their rights as corporate persons under the Bill of Rights. They believe and they want the protections, the same protections, as living persons experience under the Bill of Rights. First Amendment, right to free speech, right of assembly, freedom of the press, and all the protections under the First Amendment. The Fourth Amendment, the right to protection from illegal search and seizure. The Fifth Amendment, the right to due process, and the right not to be required to testify against yourself, to incriminate yourself. That particular protection under the Fifth Amendment is one that the courts have not been willing to grant to corporations. But my point is that corporations, as corporate persons, have sought the rights that living persons enjoy under the Bill of Rights. But on the other hand, corporations get special protections and privileges that individual living persons don't get, like limited liability protection and a number of other things. So in a sense, corporations as persons are living a dream, a legal dream. They are, in effect, able to basically have it both ways. And I think that's very significant. Let me just go on and give you just a couple of other things that I've written, and then we'll basically talk about this. In the Dartmouth College case, John Marshall explained the dual properties of immortality and individuality, which necessarily belong to these artificial beings. Marshall made the point in Dartmouth College that corporations are artificial beings. And as such, he pointed out that what makes these artificial beings unique is the idea of immortality and the idea of individuality that they enjoy. And this is a direct quote from the Dartmouth College decision. Corporations, Marshall said, are a perpetual succession of many persons, considered the same, and may act as a single individual, unquote. Marshall is saying basically that a corporation is potentially immortal because It is made up of persons, generation after generation. Some die, it's replaced by new people, but the corporation remains the same according to the terms of its charter of incorporation. So in a sense, even though the people who make up the corporation change over time, the corporation perpetually remains a single individual. As such, Marshall said, there is nothing in its charter of incorporation that either changes the character of the institution or transfers to the government new power over it. So in other words, if it is created to be able to operate free of government control in certain areas, and that is specified specifically in its charter of incorporation, then whatever might happen later on, the corporation continues to enjoy the same privileges that it enjoyed from its very beginning. And of course we know from the Dartmouth College decision that the original charter setting up Dartmouth College was awarded by the king to the Board of Visitors for Dartmouth College. It was a charter issued in the colonial period before the Revolution. And Marshall's decision was that as a corporation set up by government in order to promote the public interest as defined by government at that time, it was a contract. And the efforts of the state of New Hampshire to take control of Dartmouth College and make it a public institution rather than a private one, violated the original terms of the charter or the contract. And so therefore, Marshall in his decision says that there's nothing in the charter of incorporation that changes the character of the institution. In other words, you can't go from it being a private institution to making it a public institution. There's nothing in the charter that allows that. Nor is there anything in the charter that gives government any new power over it than it had from the very beginning. So therefore, what Marshall does in the Dartmouth College case is rule unconstitutional as a violation of the contract clause the New Hampshire law which sought to take over control of Dartmouth College. This is a case that we didn't look at. And this case occurred 3 years later, in 1822. This was a case of Providence Bank versus Billings. This is a case of a bank in Providence, Rhode Island. And in that decision, the same issue came up. And here again, Marshall is ruling that in America, corporations can literally have their cake and eat it too. And in the case of Providence Bank versus Billing, Marshall lays out the specifics of the rights of corporations as persons. And he says the following in the case of Providence Bank versus Billings. The great object of an incorporation is to bestow the character and properties of individuality on a collective and changing body of men. This capacity is always given to such a body. The whole idea of laws of incorporation, laws by which government creates corporations, the whole purpose of them is to bestow upon them the character and the properties of individuality. A law of incorporation makes a corporation a person, a single person, even though it is a group of people and the makeup of that group changes over time. It imposes the property of individuality on a collective and changing body of men. And he says this capacity is always given to such a body. In other words, every single corporation that was ever incorporated, chartered by government, whether it be at the state level or whether it be at the federal level, automatically, for purposes of interpretation of the law, becomes a legal person. And as such, it can be treated as a person. I know I mentioned this before, but I think it's appropriate here to mention it again. Most of the outrage over the Citizens United decision in 2010 was based on the court's ruling, on Justice Roberts' ruling, that the rights of corporate personhood came from the 14th Amendment, which was drafted, as we know, in 1866, right after the end of the Civil War. It's considered one of the Civil War amendments to the Constitution. We're talking about John Marshall in the 1819 and 1822. So it's very clear that the shock and the horror associated with the Citizens United case, because of Roberts' interpretation of the 14th Amendment, is misplaced. Because in effect, what the Roberts Court is doing in Citizens United is merely taking the next step in a whole series of legal steps going all the way back to the Marshall decision, which explained or defined the creation of corporations and set out to talk about the rights of corporations under the Constitution as persons. And from the very beginning, Marshall is interpreting corporations as persons. He does it in Dartmouth College versus Woodward. He does it in the McCulloch versus Maryland case, in which he rules on the constitutionality of the United States Bank. He does it in the case of Providence Bank versus Billings in 1822, and that's the one we're quoting from right now. And he said basically that what laws of incorporation do is to bestow the character and the properties of individuals on groups, changing groups of men. And this capacity of being an individual person is always given to such a body. And then he goes on in the Providence Bank case, and this is very interesting because this is interpretive. Marshall, in this case, invites corporate attorneys to spell out any privileges which may exempt the corporation from the burdens common to individuals. And Marshall rules in Providence Bank, these rights must be expressed in the original charter or they do not exist, unquote. This is very interesting. What Marshall does in Providence Bank versus Billings is justify the right of Rhode Island to tax the Providence Bank. This is one of the rights, the right to tax, that were retained by the states in the Constitution. If you remember, prior to the Constitution, under the Articles of Confederation, only the states had the power to tax. The central government did not. The Constitution changed that. Right at the very beginning in Section 8 of Article 2 on the powers of Congress, the Constitution spells out the powers of the new central government to tax. But it doesn't mean that the states lose the power to tax. Both of them retain the taxing power. And ultimately what comes out of this is that it's going to be the determination of the courts when there is a conflict between the federal government and the state governments in order to make the decision. And what Marshall is doing in Providence Bank is legitimizing the right of the state of Rhode Island to tax the Providence Bank, because it's totally within the state, and the state has not given up its right to tax it. Now, what makes this significant is that 3 years earlier in McCulloch versus Maryland, Marshall had struck down the right of the state of Maryland to tax the United States Bank in Baltimore by saying that the right to tax is the right to destroy. So what's the difference between McCulloch versus Maryland and Providence Bank versus Billings? The difference is that Providence Bank is being taxed by the state of Rhode Island. It is a corporation created by the state of Rhode Island. Therefore, Marshall says, the government that created it has the right to tax it. But in the McCulloch case, it was the United States Bank that was being taxed by the state, in this case, Maryland. And in that case, Marshall argued that state power to tax must take a back seat to the right of the federal government to create corporations, to create the United States Bank. Necessary and proper clause, which we talked about. What Marshall is doing in the Providence case, in the Providence Bank case, is not only laying out the nature of a corporation, which he's already done in both McCulloch versus Maryland and Dartmouth College versus Woodward, but he's also suggesting that if the Providence Bank needed to be exempt from state taxes, that had to be part of its original charter. If a corporation was going to claim privileges that were unique from the privileges granted to other persons, to real living persons, it had to be part of the original charter, or, as Marshall said, they must be expressed in it, or they do not exist. So in this case, Marshall is upholding the right of the state to tax the bank only because a request to be exempted from taxes was not in the original charter. Had it been, then one has to conclude that Marshall's position in McCulloch, that the power to tax is the power to destroy, would have prevailed here also. Notice what the power that Marshall is claiming for the courts to render decisions in these very complicated legal matters. But also, notice the power that the Marshall Court is giving to corporations. It is laying out the specifics of ways in which a corporation is a person under the Constitution. Yet it is opening up the opportunity for these artificial persons to request special privileges under the law that human persons do not have. So in a sense, Marshall is coming down on the side of corporations. I'm not going to go out on a limb and say that Marshall is saying that corporate persons are more important to the future of the country than are human persons. But I want you to think about that very carefully. Because the issue that prompts this whole discussion today is the Patriot Coal decision that the Federal Circuit Court in St. Louis reached this past Thursday, May 30th. Basically, what the Circuit Court did in the Patriot case was suggest that there were two positions, two issues on the table. the rights of retired miners and their family to pension obligations and health care obligations that their employer had given them as part of the unions, as part of the union contracts over the years. In other words, the company had a contractual obligation to deliver on its contractual obligations related to pensions and to health care benefits. But the company, the employer, seemingly, apparently, this is the position of the union, found a loophole in the bankruptcy laws by creating a new corporation, by changing the name to Patriot, and transferring all of these obligations to the new company. Then the new company, by declaring bankruptcy, can forfeit commitments made by the original company. In a sense, and this is the way people in this region are interpreting this decision, in a sense, what the court is saying is that there are competing issues at hand here. One is the right of the corporation, the right of the company to declare bankruptcy. The other are the legal responsibilities to its employees that the original company had created by contract. But since the original company and the new company are different, the court is saying that becomes the opportunity to rule in favor of the corporation over the rights of the human being, over the rights of the employees. So in a sense, the court is saying, effectively, that this could go either way. But the decision is that the rights of the corporation trump the right of the people. What is the potential of that decision? Are we saying that the rights of corporations always trump the rights of people? Are we saying that in this country, despite all of the rhetoric about freedom and opportunity and the value of the individual and the integrity of humanity and all the rest of it that we associate with the American Republic, the founders, if you remember, talked about the very unique nature of this republic. This was the first republic, the first government in the history of the world where the people who were to be governed by this government were given the opportunity to lay out the terms under which they would be governed, what their rights were, what their obligations were, what their responsibilities were, what government's responsibilities were, what the limitations on government power were. And then you had a Supreme Court whose job, whose responsibility was to constantly weigh and balance these particular responsibilities and rights whenever they became into conflict. It seems like what the court is telling us now in the Patriot case is that when there's a conflict between the rights of people and the rights of corporations, corporations win. That's the way that decision is being interpreted here in West Virginia. Our own newspaper had said, and our newspaper, you need to know, is not considered to be, an extremely liberal or extremely radical newspaper in any stretch. It's usually considered to be very, very conservative, very, very matter of fact. It has always been viewed that way. And so for the newspaper to, in its editorial, to come down for the side of the corporations suggests that in its wisdom, it believes even though its druthers would probably go in the other direction more often than not. It is saying, in this case, it believes that the rights of the employees have been given short shrift here, that in a sense, the employees have been, to use an expression from mining, have been given the shaft. That's what Congressman Rahal basically said. That's what Senator Rockefeller said, and on and on and on. My point is that if you go back all the way to the Marshall Court, it becomes very clear that a whole set of legal precedents and foundations is being laid from the very beginning, which become fodder for the particular decision that the courts choose to make in a case like this. The potential here is incredible, because this case involves a lot more than coal miners. It involves a lot more than one company. Congressman Rahal, in his legislation, obviously is suggesting that it involves a lot of different miners and a lot of other companies who still work for them or who have recently retired from them. But I would suggest to you that the potential of this case goes way beyond the mining industry and raises serious questions about all employer obligations to their employees. So the question, it seems to me, that we are confronted with here is a huge one. Let me kind of read my conclusion as to what I think this is all about. Despite public dismay at the idea of corporate personhood in Citizens United, the principle that most people believe was born in the 14th Amendment existed many years before. Furthermore, there is credible evidence that corporate personhood might have been the real agenda behind the 14th Amendment in the first place, not the rights of ex-slaves. That was the justification used to get the amendment ratified. Roscoe Conkling, senator from New York, a prominent member of the Senate Committee on Reconstruction that drafted the 14th Amendment in 1866, insisted years later that protection of corporations had always been the principal object of the amendment. The fact that upwards of 90% of the 14th Amendment cases heard by the Supreme Court between 1890 and 1910 involve corporations, not the civil rights of individuals, seems to confirm Roscoe Conkling's recollection. The 90% figure comes from Oliver Wendell Holmes, Justice on the Supreme Court during this period. Justice Holmes makes the case that while he's sitting on the court, better than 90% of the 14th Amendment decisions that came before the court he sat on were corporation decisions, not civil rights decisions. So one suggests that corporate attorneys were laying for this particular interpretation in the 14th Amendment. The fact that no person may be deprived of life, liberty, or property without due process of law, which is what the 14th Amendment said. And these attorneys know full well that person includes corporations. But the general public doesn't know it. The general public believes that the 14th Amendment is the Supreme Court moving in to protect the rights of ex-slaves after the Civil War. In fact, Justice Miller, who sat on that Supreme Court, makes that case later, that the 14th Amendment was about the civil rights of ex-slaves. However, Roscoe Conkling, who sat on that committee, makes the point that from the very beginning, from the get-go, corporations were to be included in the 14th Amendment. But clearly the implication is that they didn't make that public. This was something that was known by the committee and was looked forward to by corporate attorneys who were going to use the 14th Amendment for their own benefit later on. And Justice Oliver Wendell Holmes makes the case that in a very particular volatile period from the end of the 19th century into early in the 20th century, most of the cases related to the 14th Amendment that came before the Supreme Court were not civil rights cases. They were corporate cases. They were business cases. They related to the rights of corporations. And what that meant was, of course, during this period, which is the beginning of the so-called progressive period, corporations are trying to protect their rights from regulation by government. They are basically arguing that as persons under the 14th Amendment, they are entitled to the same protections from government interference that human persons are entitled to under the First Amendment, under the Bill of Rights. So in a sense, I'm suggesting that Oliver Wendell Holmes' 90% figure seems to suggest that Roscoe Conkling memory was pretty good. So also is the court's decision in 1886 in the case of Santa Clara County versus Southern Pacific Railroad. This is usually referred to as the Santa Clara Railroad case. And here is a quote from the 1886 Supreme Court decision in Santa Clara. The court does not wish to hear argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny any person within its jurisdiction the equal protection of the law, applies to these corporations. We are all of opinion that it does. 1886, Santa Clara versus Southern Pacific Railroad. The court is saying, we don't want to hear arguments about whether the 14th Amendment, equal protection clause of the 14th Amendment, includes corporate persons. Quote, we are all of opinion that it does. In 1838, in a very famous dissent to a Supreme Court case called Connecticut General Life Insurance Company versus Johnson, Justice Hugo Black argued against a corporation's right to evade taxes by resorting to the 14th Amendment. Let me read this quote, and then we'll take a break, and we'll come back after a short intermission. This is from the dissent of Justice Hugo Black in 1938. The history of the 14th Amendment proves that the people were told that its purpose was to protect weak and helpless human beings, and were not told that it was intended to remove corporations in any fashion from the control of state governments. I do not believe that the 14th Amendment fingers aren't working here. I do not believe that the 14th Amendment had that purpose, nor that the people believed it had that purpose, nor that it should be construed as having that purpose. The fact of the matter is, Hugo Black's dissent in this 1938 case was not substantive, it was wishful, it was hopeful. It was a denial It was not a refutation. In other words, what Black is saying to the court in 1938 is when the 14th Amendment was passed, this was not what was supposed to be about. The people didn't believe it was what it was supposed to be about. I don't believe it was what it's supposed to be about, and I don't think we ought to act in accordance with the fact that that's what it was about. But in every one of those statements, Black is saying, I wish we would change what has happened. He is not proving that what happened didn't happen. While he hoped that the court would reverse its record on corporate personhood, he never denied the reality that the precedent was there. Quote, I believe this court should now overrule previous decisions which interpreted the 14th Amendment to include corporations. So what Hugo Black is saying in 1938 is that the court ought not to continue to allow corporations special protections under the 14th Amendment. But in saying that, he's acknowledging that the court up until that time had continued to do exactly that. So the question I leave you with as we take our break, we've just passed the top of our first hour. Should corporations have the same rights as natural persons? Should these rights be limited? How far should corporate rights extend? Do corporations, by definition, need certain protections which the Bill of Rights gives them? If so, what are those protections? Is the court right that corporations are an important part of what a free enterprise capitalist society like the United States is about and must continue to be about? If corporations are vital to the nation's future, then what special protections do they need? And how far do those protections go? I think these are questions that all of us need to think about. We're at 3 minutes after the hour. Let's pause for 4 or 5 minutes and take a break and stretch, and we'll come back and do our second hour on today's version of the Virtual Center for the Study of the U.S. Constitution. I'm Bill O'Brien. Be right back. This is Bill O'Brien back with you after that short interlude. I love the music, by the way. Very, very pleasant. Very nice. Very upbeat. I think the topic today is a little bit upbeat. I'm kind of excited about this. And I don't mean in a negative sense, because I think the issue is very frightening. But it I think challenges all of us. We've talked about this in the past, so let me kind of put this into perspective a little bit, and then we'll go back and look at a few things, because I think this is very significant. The Citizens United case, which, as you know, in 2010, the Roberts Court, although the decision was not written by Chief Justice Roberts, it was written by Kennedy, by Justice Kennedy, basically allowed corporations, including unions, to make unlimited donations to political campaigns. And under the argument that it was protected under the First Amendment's right to free speech, that in a sense, political contributions, campaign contributions, were a form of speech. And under our Constitution, First Amendment, citizens are guaranteed the rights to free speech. And again, under the 14th Amendment, corporations are persons. Therefore, they are entitled to free speech. But again, and I think this rationale is very important, the whole idea behind Citizens United did not necessarily focus on the First Amendment rights to free speech per se so much as it did on the importance of free speech to the operation of our American Republic. The reason for the First Amendment is that the republic that the founders created demanded a free, open society where speech was unrestricted, uncensored. The idea being that this is a classic example of free enterprise in the area of speech. The idea being that in the marketplace of ideas, all relevant ideas needed to be introduced. And the idea is that in the free discussion and competition that resulted from that, the best ideas would prevail. The worst ideas would not. So in theory, we're talking theory here now. In theory, the way you find out truth, the way you discover what truth is to input the best ideas and the best opinions from the most informed people. And as these ideas are talked about and criticized and digested, the best ones will kind of rise to the top. That's what our whole idea of free speech is all about, the marketplace of ideas. The court's rationale in Citizens United is based on the idea that to deny corporate persons to participate in that process skews in a negative way the free market. In other words, the free exchange of ideas is being hampered, is being defeated if corporate persons are not allowed to participate in the marketplace. So the idea is that in order to protect the free marketplace of ideas in our political system, it is absolutely vital that we not censor or keep out important voices in that discussion. And corporate persons, the argument goes, have as much right and as much to contribute as anybody else. And so therefore, it's in order to protect the marketplace, the free market and free exchange of ideas and opinions that the court's decision is based in Citizens United. The point that I was making is all the way back to the Marshall Court, the ground rule, the precedents are being established for this idea of corporations being persons. And if you look at the history of the court, in 1976, which is 34 years before Citizens United in 2010, in a case, I believe Warren Burger was Chief Justice. This was the Burger Court in 1976. In the case, it's called the Bellotti case. It's First National Bank of Boston versus Bellotti. Francis X. Bellotti was the Attorney General for the state of Massachusetts. When I was growing up in Massachusetts, Francis X. Bellotti was Attorney General. And so this is First National Bank of Boston versus Bellotti, 1976. And the issue at hand, what the court is hearing, is whether the Massachusetts law capping the amount of corporate money that could go into political campaigns was constitutional or not. In other words, the court was ruling on the issue: does the state of Massachusetts have the right to limit the amount of money that corporations can contribute to political campaigns? And in the case of First National Bank versus Bellotti, First National Bank of Boston versus Bellotti, the court, under Chief Justice Berger, rules that the Massachusetts law is constitutional, that the state does have the right to limit the amount of campaign money that can come from corporations. But, and this is the key part, the but is the key part. In its decision, the court makes the point that the issue is not the right of corporations to make contributions. The issue is the size of the contribution. The court in 1976 is ruling, and it's specified in the Bellotti decision, that whatever the amount of money that corporations are allowed to contribute to political campaigns, the court in its decision says these contributions are and must be viewed as political speech. And then the court goes on to support the state's right to limit the amount of money, the amount of speech. And of course, the rationale for the court is that if you allow unlimited amounts of money, you would be opening up the possibility that corporations could literally buy elections, which is what corporate Citizens United effectively does. So the groundwork for Citizens United is laid in the Bellotti case 34 years before, when the court rules that corporations as persons have the right under the First Amendment to free speech, and that campaign contributions are a form of speech. The only thing that's left is to remove the caps, remove the amount of money that can be contributed to political campaigns by corporations. And Citizens United does that in 2010. It is very relevant, it seems to me extremely relevant, that in the Bellotti decision in 1976, there are two dissents. One of the dissents is from future Chief Justice William Rehnquist. I find that astounding. The other dissent was from White, by the way, Justice White. I find it incredibly significant that Justice Rehnquist, who is clearly a classic conservative in all the sense, if you read the history of his role, of his years on the court, Rehnquist, the Rehnquist court is considered to be a conservative court. In fact, those who look back on the Rehnquist court, the Rehnquist years, when he is Chief Justice, will often say that one of the key characteristics of the Rehnquist court is to limit what are seen as liberal excesses of the Warren court that came before it. Under Earl Warren, that's when many of the civil rights and citizen rights that have become so familiar to us, protection from search and seizure, the right to an attorney, the right to have your rights read to you, you have the right to an attorney, your right to remain silent, all of those things that we hear on Law and Order all the time. That comes from the Warren Court. And the Rehnquist Court begins to put limits on some of the individual citizen rights that came out of the Warren Court. Many people believe that the Rehnquist Court is a step backward in terms of the definition of citizen rights. Other people, conservatives, argue that the Rehnquist Court is merely restoring the balance which the Warren Court had disrupted by going way beyond the bounds of fairness and balance. But, you know, the argument is the Warren Court was so much in favor of granting rights to the individuals over the state that some reeling in, some sense of balance being restored was called for, and that's what the Rehnquist Court did. The point of the issue, the point of the matter is that Rehnquist is clearly a hallmark of conservatism on the court. Yet he dissents in the Bellotti case. He raises, if you read his dissent, you can go online, just Google Rehnquist dissent in Bellotti, and you'll get the whole dissent of Justice Rehnquist. And he goes through the whole history in his dissent of the idea of the court ruling in favor of corporate personhood, of corporations being persons under the 14th Amendment. And Rehnquist takes issue with it. But what he is really taking issue with, I would argue, is not the idea of corporate personhood per se, so much as the tendency of corporations to begin to claim additional rights under the Bill of Rights. By the time you get to the period when Rehnquist becomes Chief Justice, which is in the late 20th century, when Bellotti is decided in 1976, Rehnquist is a justice on the Supreme Court, but he is not yet Chief Justice. Warren Burger is. Rehnquist's dissent is aimed primarily at the inclination or the temptation of corporations to overreach this idea of person rights under the Bill of Rights. Because there's every reason to believe during this period that corporations are going to find ways to claim additional rights under the Bill of Rights as persons. They're not going to be satisfied with property being taken without due process under the 14th Amendment. They're not going to be satisfied with equal protection under the laws. They're going to look for other rights that corporations as persons have under the Bill of Rights. And Rehnquist opposes that. He acknowledges the legal precedents that the courts have established in previous decisions of defining corporations as persons under the 14th Amendment. But he is clearly opposed to the expansion of those rights beyond the 14th Amendment. A number of cases come before the courts which I would say, you know, in the vernacular, I would say, that scare the hell out of Justice Rehnquist. One of them is a case filed by Nike, the athletic shoe company. Nike is found to have lied in some of its advertising. It is found guilty of false advertising. And it claims immunity under the First Amendment. And its argument is that individual persons, human persons, can claim that they didn't know, or can claim ignorance of the law, or a number of other excuses for lying, cheating on their taxes and various other things. And corporate persons ought to have the same right. The courts rule against Nike. Nike does not win this case. But with that exception, Rehnquist is looking at a lot of other examples where corporations seem to be pushing the envelope a little bit beyond where he thinks it ought to be pushed. And I'm putting myself in Rehnquist's head here. What Rehnquist seems to be worried about more than anything else, I believe, is overreach. I think he's afraid that if corporations overreach in terms of claiming person rights under the Bill of Rights, it's going to create a backlash against corporations, which is going to prove more than corporations can handle. What Rehnquist is doing in his dissent in Bellotti is suggesting that corporations go slow and be careful and take it easy. Don't go beyond where you can safely go, because you are liable to create a backlash in this country. And you will rue the day. You will regret what you did. You could win the battle, but lose the war. In one of the articles that Rehnquist writes in a law journal, and I do not have the citation to this particular journal. I wish I did. I spent quite a bit of time today looking for it. I can't lay my hands on it, but I read it several months ago. Rehnquist makes the point that if corporations overreach in claiming First Amendment rights or in claiming person rights under the Bill of Rights, the result is probably going to be a full-fledged discussion in this country on the nature of corporations themselves. In other words, once you get the general population mad enough, then there's going to be serious discussion in this country as to where this idea of corporations being persons came from in the first place. And Rehnquist's position is that is a discussion that corporations don't want to see happen. That once the general population gets into the fray, and once individual citizens begin to think critically about the specific rights that corporations have in this country as persons, there's liable to be a backlash which will make any victory that corporations might have in the short term a Pyrrhic victory. In other words, you might win the battle, but you could lose the war. I find that incredibly telling. First of all, I find it incredibly visionary on the part of William Rehnquist. I think he's right. I think he's recognizing that corporations need special protections and special privileges. They need to be free from being overly regulated, because under their original charters, they need to be able to do certain things. And they can't do those things if government is banging on the door every day, demanding more and more information and more right to see their records and all the rest of it. So it stands to reason that if corporations are a vital part of our scene here in contemporary America, then it's very understandable that they need specific protections and rights in order to be able to do what they were created to do. But the question is, you don't want those rights to become the topic of discussion on every dinner table in the United States. Because if that happens, corporations are going to lose. Rehnquist believes that corporations will be better served if that discussion never happens. Personally, my position, based on the Patriot Coal decision from last Friday, is that it's time for that discussion to begin. I believe that the Patriot Coal decision has ramifications for the future of this country in terms of the rights of pensioners and retirees to keep their health care and to help guarantee that retirees are going to enjoy the final years of their life as retired persons. I believe that it is entirely necessary that their rights, their personal livelihood, not be surrendered in the interest of corporate persons under the 14th Amendment, under the Bill of Rights, or under anything else. And if we are going to restore balance in legal jurisprudence in this country, then I believe that it's time to begin that discussion. I believe Rehnquist is right. I think in a full-blown discussion of corporate personhood in this country, I do not believe that corporations are going to come out as well as they go into the discussion. But I also believe that America's founders believed that this country was a very unique experience in government, primarily because of the rights of its human citizens, not the rights of its corporate citizens. I believe that's an important distinction, and I believe it's one that defines or outlines a balance, a sense of balance, which I think we've lost. And while we conduct our discussions today based on the idea of liberals and conservatives, the competition between Democrats and Republicans, and whether the court is conservative or whether the court is liberal, and how many conservative justices there are, and how many liberal justices there are, and what that's liable to mean in terms of the way the Supreme Court interprets the Constitution in particular situations. I think the fact of the matter is that the legal precedents are there to find over and over again in behalf of corporate persons. I think Marshall was visionary. Marshall knew what he wanted. He knew what the country needed. He knew, as well as anybody else, that this country needed to develop the kind of economic independence that his contemporary Alexander Hamilton saw in the economic program that he proposed to Congress in the 1790s, in the first years of the Washington administration. Hamilton couldn't get a substantial portion of his program through Congress. It took 15 to 20 years of very negative experiences in order for the nation to realize, after the War of 1812, that we needed internal improvements. We needed corporations in order to develop the economic potential of this country. We needed corporations that were relatively free of the political constraints and the political controls imposed upon them by government, whether it be federal government or whether it be state government. We needed internal improvements. We needed government's ability to develop roads and railroads and canals in order to maximize the commercial potential of this country and allow the economy to become all that it could be. We needed all of these things. So I'm not denying the value of corporations, but I am emphasizing the value of people. I am emphasizing the fact that this nation was created, the founders created this nation to provide a very special and a very unique opportunity and experience for individual people. Citizens of this country, every one of them as an individual, possessed value. This was the first nation in the history of the world that expressed in its founding documents and its founding philosophy the value of the human being, the value of individual freedom, the value of the dignity of every individual person, irrespective of race, irrespective of religion, irrespective of national background, irrespective of the family that you came from. In this society, governed under the principle of rule of law, every individual was to be treated equally under the law. Every individual had value. Every individual, it was assumed, had potential. And the potential greatness of the nation was the sum total of the individuals within that nation being free and receiving the support they needed to reach their full potential, and being able to will that freedom and that opportunity to their children and their grandchildren and their great-grandchildren. That was the basis of American exceptionalism. All this other stuff has no, I do believe, has no basis in reality. But this does. The United States of America was the first nation in the history of the world to put down on paper, to put down in black and white, that its principal objective, its principal motive, its principal reason for being was to carry out the message of Matthew and the idea of the Sermon on the Mount, the Sermon on the Mount. Matthew's gospel laid out essentially the idea that we would be judged according to the way we treated each other. And I would suggest to you that this nation was created around the principle of making the potential of Matthew's gospel a reality in the world. I believe that that's what made this particular society the potential of being a city upon a hill. That was what made this nation special in a world of nations. That's the basis of American exceptionalism. And it seems to me that it is short-sighted and naive to allow this issue of corporate persons being human persons to actually become a reality in our legal system, which might end up pushing the rights of individuals into a second-class category in the face of corporate personhood and corporate rights. I don't think that's what the founders intended. In fact, there is quite a bit of evidence to suggest that the founders were aware of that potential and went out of their way to make sure that it didn't happen. When he was president, during the years that Jefferson was president, from 1800 to 1801 to 1808, Jefferson made the following statement: "I hope we shall crush in its birth the aristocracy of our moneyed corporations, which dare already to challenge our government in a trial of strength and bid defiance to the laws of our country." His Jefferson warning early in the nation's history about the tremendous danger of corporate power and corporate control of wealth in this country. That ultimately he recognized the threat, and he was basically calling forth government to see that threat and to do something about it. In 1787, when James Madison sent his first draft of the Constitution to Jefferson, Jefferson's response to Madison's draft of what becomes the Virginia Plan, the Constitution of the United States, Jefferson's response is that he insists on annexing a Bill of Rights to the new Constitution, i.e., a bill wherein the government shall declare that 1. Religion shall be free, 2. Printing presses shall be free, 3. Trials by jury preserved in all cases, 4. No monopolies in commerce, 5. No standing army. So here is Jefferson's response to Madison's initial draft of the Constitution of the United States. He lays out the ingredients of what becomes the First Amendment in detail. But one of the things he includes, besides religious freedom, freedom of the press, the right to a trial by jury, and no standing army, the fifth one is no monopolies in Congress. In commerce. When he was president, James Madison said the following: "There is an evil which ought to be guarded against in the indefinite accumulation of property from the capacity of holding it in perpetuity by corporations. The power of all corporations ought to be limited in this respect. The growing wealth acquired by them never fails to be a source of abuses." Unquote. This is the author of the first draft of the Declaration of Independence, of the Constitution of the United States, James Madison. And already he's warning about the potential power and abuse of corporate control of money and their ability to directly influence the rights of people and the nature of our Republican form of government. When he was president, Andrew Jackson made the following statement: In this point of the case, the question is distinctly presented whether the people of the United States are to govern through representatives chosen by their unbiased suffrages, or whether the money and power of a great corporation are to be secretly exerted to influence their judgment and control the decisions. And of course, the great corporation he's talking about is the bank. And what he is basically suggesting is that the United States Bank potentially skews in the favor of corporations and big money the entire political system of our society. It makes the whole idea of government by elected representatives chosen by unbiased suffrages meaningless. Theodore Roosevelt, many of us know in his very famous New Nationalism speech, Theodore Roosevelt makes this comment in that speech. I again recommend a law prohibiting all corporations from contributing to the campaign expenses of any party. Let individuals contribute as they desire, but let us prohibit in effective fashion all corporations from making contributions for any political purpose, directly or indirectly. The fortunes amassed through corporate organization are now so large and vest such power in those that wield them as to make it a matter of necessity to give to the sovereign, that is, to the government which represents the people as a whole, some effective power of supervision over their corporate use. In order to ensure a healthy social and industrial life, every big corporation should be held responsible by and be accountable to some sovereign strong enough to control its conduct. In 1906, Teddy Roosevelt said the following: behind the ostensible government sits enthroned an invisible government, owing no allegiance and acknowledging no responsibility to the people. To destroy this invisible government, to befoul the unholy alliance between corrupt business and corrupt politics, is the first task of the statesmanship of the day. What Roosevelt is saying is what Madison said, and what Jefferson said, and what Jackson said. The greatest threat to everything that this nation stands for on paper in black and white is the potential power of corporate influence and corporate money. And a lot of that influence and a lot of that power came from the court's considered necessity of defining corporations as persons and giving them the kinds of protections from government control that these unique artificial persons, that's John Marshall's term, these artificial beings needed in order to be able to fulfill the responsibilities to the general welfare that accounted for their original incorporation. When companies are incorporated, they are required to make statements as to what the corporation is about, how it will operate, and what its benefits to the community at large will be. Because the corporation is going to get special benefits, special rights. Therefore, it needs to demonstrate that its very creation and its operations will be in the public interest. Because government's responsibility is to promote the public interest or the general welfare. And by giving these corporations a special charter, special protections, as special people, as unique persons, if you will, then government is giving corporate persons, in many ways, more rights than human persons get under our Constitution and under our Bill of Rights. And the fact that Rehnquist in 1976 saw that if corporations abused this opportunity, abused these privileges by demanding more and more and more. And I want to go back to the Nike case again, because what Nike was asking for was the right to lie. It was asking for the same rights to lie and claim ignorance under the law that individual persons got. And government, the courts would not go along with that. But that just shows you how short-sighted many of these corporate attorneys could be. Their priorities became skewed. They were interested in short-term benefits, even at the expense of long-term mistakes. And that was the issue that alerted Rehnquist. Rehnquist was warning the nation, warning corporations, that the biggest mistake they could make is overreach, demand more than the people in this country are willing to give you. If you don't make waves, we're doing fine. But if you make waves, you're going to raise the raise the hackles, if you will, of the general population, and you're going to rue the day that you made waves. Examples of these waves: one of the major issues that all of us deal with today is the extent to which American corporations are hiding income offshore in order to avoid taxes. We all know as individual persons what can happen to us if we get into it with the IRS, if we falsify our income tax returns, if we don't report income, if we claim deductions that we're not entitled to under the tax laws. But here we have corporate persons who are not only able to evade their person responsibilities under the Constitution by shifting income overseas. We looked the other day at Apple stashing tens of millions of dollars in Ireland and then looking for a tax holiday as a way to bring that profit back to the United States without paying the same level of income taxes, of taxes on it that individual citizens pay. And the result is, through all sorts of loopholes, which many of these corporations are responsible for creating in the first place, corporations are able to end up paying proportionally a lot less in taxes than we citizens pay. They are doing exactly what Rehnquist hoped they wouldn't do and urged them not to do, which is to overreach. Don't demand so much that you will draw the attention of the citizens of this country. Because once you draw that attention, then you are inviting an open, free-range discussion on the nature of corporations in this society. And Rehnquist believed that that was a discussion that he didn't think corporations could win. Better to let sleeping dogs lie, better not to make waves, better to cool it. but with offshore tax havens and with the tremendous inequity in wealth and income in this country, the power and the influence of the so-called 1% in this country as opposed to the 99%. What's happening is that individual citizens and corporations are doing exactly what Rehnquist hoped they wouldn't do. What I am about today is I am basically suggesting that I disagree with Rehnquist. I believe that the benefit and the best interests of this country and the people in it demand that this discussion happen. That citizens everywhere begin to understand the nature of corporate personhood, where it came from, why it was created in the first place, what its intent was, and what evidences of overreach there might be. I am not an advocate of abolishing corporations. I am not an advocate of overregulating corporations. I am more than willing to accept the rationale of minds like John Marshall's and Alexander Hamilton's, who saw the future of this country wrapped up in the success of corporations, the ability of individuals to unite and to pool capital and to make things happen economically in this society. Primarily because when those things happened, individual citizens in this society were able to realize the full potential of a society committed to the idea of equality of opportunity. I am willing to accept the reality that the opportunities for all of us are dependent on the unique opportunities available to a few of us. I'm willing to accept that. However, like Rehnquist, I am uncomfortable with the overreach. I am appalled by the court's decision in the Patriot Coal case. I am fearful for the response that the United Mine Workers might take to this decision. One of the things that had bothered me in recent years is the fact that while the coal industry has been shrinking and the number of jobs has been shrinking incredibly fast, while coal companies have sought to pin the blame for the reduction of jobs on the federal government, on the Obama administration, on the EPA, and on what they call the war against coal, the fact of the matter is coal jobs have been decreasing most rapidly because of technology in the industry. And what has bothered me is that while this is happening in other industries, those in coal have primarily been comfortable and most concerned with looking out for themselves. The fact of the matter is the Patriot Coal decision is not new. Those kinds of decisions against pensioners and against health care benefits for retirees have been the order of the day in other companies and other industries for a number of years. Where were the coal miners? Where were the coal unions when this was happening in the steel industry? It seems to me that what has to happen is an informed discussion where everybody sits down and we basically begin to reevaluate our rights and priorities in this nation. Let the discussion begin. We are at 58 minutes after the hour. We'll be back tomorrow. I've enjoyed being with you today. I hope that today's program you have found worth the investment of your time. Please be safe. Be careful. We'll be back together again tomorrow. Be safe.